Welcome to Discussions with the Writer Fred here in San Antonio, very, very hot San Antonio. For those of you who are going to be part of the delegation with the NAACP coming here in July, wear really light clothes because we're at 100 degrees already and it is hot out there. Today we're going to discuss an issue that's raised its ugly head over the last year or so, starting probably with the Bill Cosby case and then going to Harvey Weinstein and then to Morgan Freeman and a number of other individuals who have been accused of sexual harassment or sexual assault. And so I struggled with those two terms. I think I know the difference, but I wasn't sure. So I invited two of our finest attorneys here in San Antonio to come in and discuss how the legal terms work on each one of those words. And I want to welcome back again, after a long time, Chris Petard of Petard Legal Firm here in San Antonio, and also Ms. Rosie Gonzalez, who is, by the way, running for office. She's running for county court at law 13.
Yes, sir.
And she's a friend of mine. We've served on the Police Chief's Civilian Action Advisory Board for years, and I want to welcome you here for the first time.
Thank you so much, Fred. It's a pleasure to be here.
Okay, so let's get right into the subject. Rosie, how do we make a distinction between sexual assault and sexual harassment?
Well, from a traditional view, sexual harassment usually is a pattern of behavior that we see in the workforce, in the work environment,
Okay.
in most cases. When you hear the term sexual harassment, you're thinking about civil court, civil litigation. When you hear the term sexual assault, that is a legal term of art, that is a crime for which you will face fines and possibly jail time, depending on the severity of the crime. If you're found guilty or plead to some sort of variation of it or it itself.
Okay.
And so one has criminal implications, the other is civil. With the crime, there are specific elements of behavior that need to be proven to a jury or a judge, the trier of fact, beyond a reasonable doubt. So those are the two basic differences.
Oh, okay. I'm an employer. I wouldn't do anything like this because I respect everyone too much to do this. But I'm an employer. I got a good-looking young lady working for me, and she walks by and I go pop on the butt. What is that considered?
I think you could probably look at it from both angles. It's a work environment. Does it create a hostile work environment? Was it unsolicited, unwanted, unprovoked? Was it meant to intimidate her as an employee from a person in power? Okay. Is her employment contingent upon her accepting that inappropriate advance? Now, that's one side of the street. What if you're on the other side of the street and that young lady invites it and welcomes it? Is it harassment? Is it an assault? If the receiver has no issue with it.
Okay.
So we would have to flush it out much more to come to some level of determination.
We're going to come back to that. Okay, but Chris has got an example he wants to share with us.
Well, before I get to the example,
yes,
let me talk a little bit about kind of what the legal standards are for harassment.
Absolutely.
And then sexual harassment as well.
Okay.
In order for there to be harassment which causes a hostile work environment, the behavior that you're complaining of has to be either what's called pervasive or severe. Pervasive being that kind of conduct that's over a period of time. For instance, if every day that I come to work, if I'm female, and my boss says, "Hey baby, you really look good today," and that tends to offend me, but I don't say very much about it. But it happens every day that I come to work. After a period of time, I get tired of hearing that and complain to somebody about it. That may be considered pervasive because it's happening every day, and I find it offensive. Severe is similar to the incident that you just described, where if I'm walking by and I'm female and my boss slaps me on my behind, that might be considered severe because it was a one-time incident, but that one time might be enough to create a hostile work environment for me because it's changed the terms and conditions of my environment there at work. There's coworker harassment, and then there's supervisory harassment. Coworker harassment is when a coworker is the one who's making the jokes or saying the phrases or doing things that tend to offend me as a female. When a supervisor does it, that's a little more consequential because, as she said earlier, there could be a quid pro quo where the supervisor is anticipating that if I do something for him, he's going to do something for me. So there may be that sexual put out, if you will, that, you know, I make advances towards you. If you respond in kind, then I'm going to promote you or give you a raise or whatever. That would be quid pro quo. But if I refused your advances and he takes some sort of adverse action against me for that refusal, then that's more tangible. That's something that the employer can be held accountable for or held liable for. The supervisor has harassed me, I've rebuffed him, and then he's taken action toward me, either firing me, demoting me, something else like that. So those are kind of the more contemporary, more typical kinds of sexual harassment that the courts deal with. The example that came out this past week, though, is a little different because now we're getting into the area of students. Mm-hmm. And in particular, this past week, there was an article, a story that came out about two women at Texas A&M who had complained about two different types of behavior. One complained of rape, and that goes into the category of sexual assault. The other one complained that she was tutoring someone and that person exposed himself to her, which goes in the category of sexual harassment. Both of them brought their complaints, though, to the media because the university allowed those two people who were athletes, they suspended them temporarily and then brought them back.
What do you mean brought them back?
They brought them back so that they could continue to compete for Texas A&M University. Correct. And that's why this has come out in the way that it has, because these women have felt that Texas A&M has betrayed them in not taking permanent action against these athletes. One was a swimmer, and I think one was a football player. And now that they are back competing in their sports. And now this has come out. But as far as the two examples are concerned, one would be considered certainly sexual assault, and that would be the alleged rape. And the other one where he exposed himself, even though he didn't touch her or do anything else to her, he certainly can change the conditions under which she was working, with him, that was the tutoring part. So yeah, he exposed himself and did some indecent act to himself.
Okay.
So, but not,
we know.
but not to her.
And one of the things I do want to highlight is that harassment and or assault are gender blind. So it doesn't necessarily have to be a female on the receiving end. It could be a female that's doing the harassing to a male.
Right.
It could be a female that assaults another man. It could be same-sex type of harassment, where it's a male on male or female on female.
What if however you want to put it, male, female, the one agrees to enter into a sexual relationship because he or she's going to get promoted. Now, after the promotion, the person who promoted them wants to continue the sexual relationship, but that person doesn't want to. So whatever the person who started the sexual relationship does to her, would that now be harassment? Can it switch over?
Yes, it can. There are instances, and it doesn't necessarily have to be a quid pro quo relationship. It could be just consensual sex, or a consensual relationship between an employer, a supervisor, and an employee, which is always dangerous anyway. Shouldn't happen. And I'm sure there's policies against that in whatever corporate environment you find yourself in. But regardless, if it happens, then it creates a situation for the employer and for the supervisor where if the employee says, okay, I'm tired of this, and the supervisor decides he or she wants to continue the relationship, then you're right. The employee at that point can say, I'm being sexually harassed because I've told him no. I've broken off the relationship, and that's the end of that. I actually dealt with a situation like that with one of our employers here in town, and there was a consensual relationship between the person who was in power and an employee who was not. And at some point, that relationship stopped, and the supervisor wanted to continue it, and the employee did not. And eventually, the employee brought sexual harassment complaints against that supervisor, and that supervisor was terminated as a result of that.
And
ahead.
so you usually hear the complaints come from corporate types of environments, but it doesn't have to be a huge corporation. It can be smaller businesses. It can be mom and pop operations.
But they have to have at least 20 employees in order to be subject to the laws of anti-discrimination from both the state and federal government.
Well, now, is sexual harassment considered discrimination?
Absolutely.
In what way?
Anytime that each person has their own unmitigable traits. What I mean by that is, for instance, you're black, you can't change that.
Right.
Okay, you're a male.
Yeah.
I was going to say you can't change that, but you could.
Possibility, yes.
Yeah, but typically you can't. But anyway, you're older than 50. Okay, those are things that can't be changed about you. If someone were to start harassing you because of those kinds of factors, because you're black, or because you're older, or because you're male, or because you're female, or whatever your religion is, that comes under the protection of the Title VII, the Civil Rights Act of 1964, or under state law, because it is a form of discrimination. They are changing the terms and conditions of your employment, and you are protected from that kind of conduct towards you. So yes, harassment is considered a form of discrimination.
Oh, I didn't know that. Yeah. So, how do you, if this man says, "Hey, baby, you're looking good today," and it just builds her ego for about a year, and now she's tired of it, and she wants to bring sexual harassment, and he or she can prove that it was okay for a year, but now it isn't. So how's that sexual harassment?
I think we get to the point where we have to say no means no. And what we mean by that is at the point where you don't have two consenting adults consenting to engage in certain behavior, and one of them says, "Hey, I'm out. I don't want to do this anymore." Then any behavior that goes beyond that, against what the person wants, would be considered as an unwanted, unsolicited.
But
event.
isn't that unfair?
If I give you notice, I say, "Fred, stop doing that to me. Fred, please stop saying that."
But shouldn't you have done that right from the very beginning?
And now I'm changing the rules. And I said, "I'm done."
But why do you get the right to change the rules?
Because I just married somebody last week, Fred, and you just need to stop.
Okay, that's a little different.
Okay.
Yeah.
There's also two.
Yeah.
There's also two components to whether certain types of behavior creates a hostile work environment. Earlier, I talked about severe and pervasive as far as the conduct itself is concerned, but it's also the perspective of the individual that's receiving the conduct, as well as what's called the reasonable person or objective perspective. So, as an example, that whole "hey baby" thing, how you look pretty good thing, over a period of time may be subjectively offensive to me. Somebody from the outside, a reasonable person, may say, "Well, that doesn't seem that bad to me." And you have to overcome both of those criteria in order to establish enough of a prima facie case in order to make a claim going forward into court, that you have to satisfy both the subjective perspective as well as the objective or reasonable person perspective. So what's subjectively offensive to me may not necessarily be objectively offensive to somebody else. Even though I've told you I don't like that particular comment, even if you continue to make it, still a reasonable person would have to consider whether or not that in fact is something that is harassing and creates a hostile work environment.
And when we're talking about work environment, I've seen suits where people on the outside, maybe one or two desks over, one or two cubicles over, the other side of the cubicle, are the audience to behavior as between two individuals.
Okay.
And they're offended. And they
By
don't
the
like it.
behavior.
By the behavior. And so courts look at that too.
Really?
Yes, because it creates an environment.
Okay.
But also that would meet the objective perspective, because these aren't the people that it's directed at. They're listening, they're watching. And if they found it offensive, then you would meet the reasonable person standard.
Okay. Let's talk about if I don't want to use any names, but we know a very famous producer
Okay.
who has had all kinds. In fact, he's now been accused of sexual assault. Let's say a young lady wants to make it in Hollywood, and she goes along with it. has sex with him, and then years later she wants to bring charges. And let's discuss that when we come back from our break. Okay? Thank you. We'll be right back with you on Discussions with the Writer Fred.
40% of food in America is never eaten.
Marie, you have prediabetes.
Prediabetes? I don't have time to eat right or exercise. I'm a busy mom.
Oh, you're a busy mom.
Yeah.
This is great news. Busy moms never get prediabetes.
Wait, what?
Let me just... Yeah, this is all the people at risk for prediabetes, and way over here, busy moms. No?
Hey, you.
Yeah, you. Getting that college education, what are you gonna do? Graduate and take some office job? Be like everybody else? Or will you dare do something different? Like, be a teacher. You could be my teacher. You got the skills.
The smarts?
Yes, you. You could be the teacher I never forget.
That'd be cool.
Does that corporate job even have recess? What are you gonna make of yourself?
What are you gonna make of me?
Nothing to do this week? Don't miss another event. Go to blacksinsanantonio.com for our event calendar. The home of the largest business directory in San Antonio with an African American focus. Sign up today for our weekly e-blast and text message alerts. Help us make this a better community. Connect, empower, grow.
Welcome back to Discussions with the Writer Fred. And I have two fantastic local attorneys here, and we're discussing the whole issue of sexual harassment or sexual assault. And Chris, before we get started, haven't you had a new publication that just come out? He's an attorney, but he writes children's books.
I do. I had a children's book that just came out this past month called The Continuing Adventures of the Carrot Top Kids. And this first one is entitled The Puppies. And it's available on Amazon.com and on iTunes as well as an ebook. And my second one should be out by the end of August.
Great, because there's an article in New York Times a while back that we didn't have many black writers writing children's stories about black kids. And in my day, there was none at all. So it's good. I congratulate you on taking on and doing those stories for our kids.
Thank you.
Yeah.
We try to get some from put in the foster care children's room over at the courthouse.
Hey, let me know.
Yeah. Okay,
I can donate.
great.
I can donate a couple. Sure.
There you
Okay. Yeah. Okay. So we're going to pick up our discussion, and let's say, what's it called, the casting couch? Let's say you laid on the casting couch, and as a result, you made millions of dollars, and then all of a sudden you want to go back and claim sexual assault because you didn't really agree, you didn't really want to have the sex. You did it almost in a coercive situation to get to where you want to go. How does that work out? Or does it at all?
I think we have to put it in context, and I believe there's been a huge culture shift, and where a couple of decades ago, 3 decades ago, people in the industry would anticipate and expect that there had to be that type of what Chris called quid pro quo. Mm-hmm. You do something for me, I'm going to cast you in the movie of your dreams. You
right.
know? And I think there's been a shift in culture and how that is perceived now. And today, post Me Too movement, that's seen as an inappropriate way of trying to have that quid pro quo with the prospective actress. But it changes also. I'll give you an example in science. Mm-hmm. I've been very close to 4 women here in San Antonio who were convicted on what was believed to be good science, okay? That was presented at their trial on aggravated sexual assault of children back in the 90s. The science was then vetted out and deemed to be junk science. And that was the linchpin in undoing their conviction and then eventual exoneration for that crime. So as much as there's a shift in science, here we're talking about a shift in culture.
Right. Yeah. Well, okay. There's a shift in culture. And I laid on that couch. Now I'm ticked off because the culture's changed. These young girls don't have to do it. Well, why was I forced to do it? And my God, I'm gonna go sue and get me some money or get this guy convicted. How does that work out?
Well, okay, first of all, it was never right. The culture now has been more about exposure as well. So that's why some of these things have been coming out about things that have gone on in the past.
Okay.
That people now feel stronger, more empowered to expose those things that have been kept quiet, or as we might say, a well-known secret.
Mm-hmm.
The casting
Right.
couch being one of those things. But at the time it happened, it was still illegal. It was still unlawful. That was still quid pro quo. Even though the woman might have benefited from it overall, maybe she made a lot of money, it still doesn't matter that she had to do that in order to get the role. That still made it unlawful at the time. The fact that she's now coming forward and exposing it for what it is means that she feels empowered enough to do so, because the Me Too movement helped to do that. That's why a lot of these actresses have come out of Hollywood saying, yeah, me too. These things happen to me as well. These things happen to me as well. So it doesn't mean that a person can now sue, because the statute of limitations has long run from that sort of thing.
Right.
Okay. Whether it was sexual assault or whether it was consensual and quid pro quo sexual harassment.
So they can't even sue in civil court.
No, they can't. And
Statute of limitation applies to civil and criminal court?
Absolutely.
Okay.
There's a statute of limitations for every kind of action except murder, from what I
right.
understand.
Okay. Yeah.
Everything else, there is a statute of limitations.
Okay.
In the Bill Cosby case, as an example, if you recall, Gloria Allred brought all these persons
Right,
who
yeah.
Bill Cosby had allegedly assaulted at some point or harassed at some point. You notice there was only one criminal trial.
Right, yeah.
Because the rest of them, the statute of limitations had run out on their claims. Some of them go back as far as 40 years. They weren't going to be able to bring those kinds of claims. But what they did was they brought them in as witnesses to show a pattern of conduct by Cosby over the period of time. But they themselves could not bring claims on their own.
Well, if statute of limitations run out, why can they bring them in? Because you're adding, or you're giving someone of credibility to the case that is still alive.
That's exactly why they bring them in, to give credibility, because if that person had to stand by themselves, it would be their word against his. But when you bring in 40 women that have said, he drugged me, he raped me, he drugged me, he did this, over a period of 40 years, then you have given the person who's now bringing those allegations a lot more credibility, because it has shown a pattern by this particular individual.
And it's not just in the entertainment industry, which we've been focusing on. The same thing happened with the gymnastics girls.
Yes.
And the
Yes.
same line of girls, statute of limitations.
215 or whatever it was.
Statute of limitations had run on many of them, but they came in to give that boost to credibility to the live pleadings before the jury, and they came in at sentencing to have the jury consider what the sentence should be in this particular case.
Yeah, but there's an assumption there when they can do that he did it to them too. And if statute of limitations has run out, why should they be able to do that? That shouldn't even be
Because
brought up at all.
the law allows it.
Okay, I guess that's
took the words right out of my mouth.
That's
Yes.
a good enough reason. So, would you agree that the law is not always, what I say, rational and doesn't follow a logical plane to me?
Well, actually, let's look at it this way. You have a person of power who has taken advantage of someone who is not, okay, a young girl. And that young girl brings a complaint against him. In this particular case, the doctor or against Cosby or whoever it is in power. Who's going to be more believed? The person in power or the young person bringing those allegations? More than likely the person in power, unless you can level the playing field for that person who's bringing the allegations. And one way to do that is to find other people who have similar allegations. Even if their own claims may be outdated and may not be applicable as far as any damages, they certainly can give credibility to the person if they can come in and give credible testimony about what happened to them. And remember, they had to give testimony under oath. Okay, so you have to give them that much credence because they are under oath.
Well, that doesn't mean anything.
It does mean something.
Well, that means something.
As a lawyer, you would say that.
No, but no,
people lie all the time.
There's mechanics in here. So mechanics would include pleadings from the party that's being accused saying, I did not do that, under oath, verified pleadings. I swear under oath I did not do that. You can bring in someone to say, wait, he's lying. We're going to impeach you. We're going to say, you're lying under oath. You know why we know that? Because we have a pattern. We can establish a pattern of your behavior that you've denied under oath.
Yeah, but you're convicting a person based on behavior towards other people.
That's right. You're taking a monster off the street based on what he's done to other people, as well as the person who's actually brought the claim.
Yeah, I agree with that. The only thing I have problems with is bringing in a person whose statute of limitations has run out, and they're no longer. My question would be, why didn't you do that before the statute of limitations?
The statute of limitations only
applies to the person, that individual who's brought the claim. The other people are being brought in as material witnesses to build up circumstances to give weight to this individual's claim and suit.
The statute of limitations only limits your claim for damages. It does not mean that what you're saying is not true.
Okay.
But you just can't bring claims of damages against that person because, yes, statute of limitations has run out. But it doesn't mean that what you're saying isn't true and that the person didn't do those things to you. Maybe there were other reasons why you didn't bring those claims at the time. Who knows what those reasons were? But in fact, if you testify that this has happened to me, it impeaches that person's testimony that he didn't do anything or has never done anything like that.
Is this comparable to the young lady? They wanted to get Clinton based on Paula Jones, but that was just his word against her word. And then what they got was Monica Lewinsky, and that gave credibility to what Paula Jones was
And now
saying.
you're talking
Is that the
time,
same?
place, and manner. Okay. My recollection, Paula Jones was pre-presidential Clinton.
Yes.
Monica Lewinsky was in the White House, in the Oval Office, under the desk kind of thing.
Yeah, but the charges were
Right?
It wasn't brought against him because of Monica Lewinsky. The case was Paula Jones.
And so we go to time, place, and manner. And so they're very different cases when we talk about what transpired throughout the Clinton administration and prior to the Clinton administration.
So, but weren't they trying to prove? Well, the Republicans were trying to prove that he's a lowlife, okay? And to bolster that, they brought in what he did with Monica Lewinsky. Would that be the same with Cosby when they brought all these other ladies in to testify against him? And I guess with Harvey Weinstein too, right?
And again, it's all in context because the term low life is the definition has definitely changed over the last couple of decades.
I just threw that out
low
there.
life pre-Clinton compared to low life today is quite different. I think everybody would agree.
Well, what do you think is going to happen as we go forward with these kind of charges? You think we're going to get more of them coming out?
Absolutely.
I think the light has been shined and shown where the darkness has been, and I think once that light has brought forth matters that traditionally victims and mostly women were taught to be quiet about, and now they've been emboldened to have a voice. That voice is, I think, going to get louder and more frequent and stronger amongst victims and women and survivors.
Some persons that you may not even think about that might bring these kinds of claims. For instance, the Washington Redskins cheerleaders are not only bringing suit against them for equal pay issues, but also for sexual harassment. The Houston Texans cheerleaders, same thing. Dallas Cowboys cheerleaders this past week filed suit. Well, at least one of them did. And it may end up
Cowboys?
Against the Cowboys but that was for equal pay, not necessarily sexual harassment. But what we're talking about are groups of people that you wouldn't even think about actually empowering themselves to bring claims against some of the teams in the most watched and the biggest sports league in the country.
And that leads me to the Miss America pageant just got rid of their bathing suit portion of the competition. But when I say that, we don't have a Mr. America pageant.
No,
we don't see gentlemen in Speedos or bathing suits.
Right.
It's a very gender, divided type of competition. So you're going to do away with bathing suits, and what is this competition going to look like 5 years from now? If we're going to step in line with not looking at individuals based on gender preferences and what you find attractive in that individual, but you're going to look at other areas. I mean, why wear a bathing suit if that's not what are you measuring in a bathing suit competition? You know, what are you accruing points for?
Right. This somewhat is similar, from my thinking, to the women's movement of the 60s. I think that was the first wave of the Now movement.
Maybe
and
the
women.
suffrage movement of the voting rights.
Oh, you go back to the suffrage movement. Yeah.
Yeah.
It's been like it continues to expand to now where women are really taking control of their lives. And I think that's outstanding. You know. So let me get your last comments on this whole issue. Chris, we start with you. Tell us what's going to happen as we move forward.
There's a difference between sexual assault and sexual harassment. Sexual assault, as we discussed earlier, is in the criminal realm. Sexual harassment is more in the civil realm, and can occur both in the workplace. It can occur in the world of academics, and it can occur just about anywhere where people gather together. Mm-hmm. So I think that men need to be more aware of how they conduct themselves around women.
Okay.
I agree with Chris, and I'll take it a step further. We all have to be careful about how we conduct ourselves amongst each other. There's acceptable professional behavior. There's unacceptable unprofessional behavior. I think with time, we're going to see this kind of flush out in a very fluid sense, because it is gender blind, it is racially blind, it is culturally blind, and we are sexual animals. And we're going to have to relearn how we raise our children, what our expectations are of our sons and our daughters, and our whole value system is going to have to shift to make sure that everyone feels respected in our communities.
Okay. Thank you all. I appreciate it. And
Thank you.
I think that any kind of abuse towards a man or a woman is not called for, and that those that are doing that really have to rethink their thinking and stop doing it, folks. Stop doing it. We don't need this in our society. And so I want to thank you for tuning in to Discussions with the Writer Fred, because we are telling our story our way.